From the material brought on record of the writ petition, it appears that a copy of the instrument in question fell for scrutiny before the sub-registrar Gautam Buddha Nagar, who on 7 December 2012 put up a note for consideration of the second respondent, asserting therein that the instrument was in respect of a property which had been valued at agricultural rates. In the opinion of the sub-registrar, the property comprised in the instrument was liable to be taxed at the rate rupees 6,500 per square meter, being the circle rate prescribed by the second respondent for residential properties. Consequently, the sub-registrar opined that the instrument should be subjected to additional stamp of rupees 7,14,650. Taking note of the aforesaid report, the second respondent assumed jurisdiction and issued a notice dated 30 August 2012 informing the appellant that proceedings in respect of the adequacy of stamp duty paid on the instrument in question were pending before him, and that prima facie it appears that the appellant has evaded stamp duty to the extent of rupees 7,40,650. This notice accordingly called upon the appellant to participate and show cause why additional stamp duty, together with penalty, be not imposed upon him. The appellant filed his response in the proceedings on 28 December 2012. During the pendency of the proceedings, he is stated to have gifted the property comprised in the instrument to his wife Srimati Vijaya Jain on 17 December 2012. Para. During the course of the proceedings before the second respondent, an order came to be passed on 23 October 2013 calling upon the sub-registrar to conduct a fresh site inspection of the property and submit an actual status report. Pursuant to the aforesaid order, the sub-registrar is stated to have submitted a report dated 16 November 2013 proceeding recording therein that the property in question appeared to have been put to use as farmland. The second respondent, upon a consideration of the material before him, has proceeded to hold that the land in question falls in the vicinity of the Greater Noida Industrial Development Area, where land is largely being used for residential and commercial purposes. He proceeded to hold that bearing in mind the area of the property, it was not possible to be utilized for agricultural purposes, and that the appellant himself owned no premises in the vicinity of the land in question, which may lend credence to the contention that the property was to be utilized for agricultural purposes only. On a consideration of the aforesaid facts, the second respondent accepted the initial report submitted by the sub-registrar on 7 December 2012 and proceeded to pass the order which was impugned in the writ petition. The order passed by the second respondent against Srimati Vijaya Jain was subjected to challenge in a writ petition which too came to be dismissed by the learned single judge on the ground that she had any equally efficacious remedy of filing an appeal under Section 56 of the Act. Over.